Good afternoon, everyone. This is Ann Badmus with Badmus Associates. We also have attorney Celsa Rodriguez on the presentation with us today as well. I want to welcome you all to our monthly webinar. Today's topic is green cards for top international professionals. So we'll get started in just a minute, but before we do so, I just want to test our sound or audio. So if you could just put into the chat box whether or not you can hear me. Anyone could just put, I hear you, something like that. Great. Thank you so much. Appreciate it. Okay, so the good thing about a webinar is that you can ask questions at any time. So we do want to give you the opportunity to ask questions, but we'll do so towards the end of the presentation. But in the meantime, as we go along, make sure that you go ahead and type your questions in the Q&A section of your screen. So if you are facing your screen at the top right, there is a question mark bubble that you would use to ask questions rather than in the chat area. So also with respect to those questions, make sure that you ask your questions in a general manner because this is an open forum. Those questions can be seen. And so we want to be sure that you do not include any personal details that could identify you because we want to make sure you maintain your confidentiality as well. So with that being said, I'd like to go on and tell you a little bit about our firm. Badmus Associates has worked with immigration clients since 1993, and we've had several recognitions, such as Best Lawyers in Dallas for immigration by D Magazine, as well as a nationwide list of best law firms and best lawyers in immigration as well. So that's just a very brief introduction about ourselves, and for those of you who aren't familiar with our firm. And also, as lawyers, we want to be sure that you understand that this presentation is really for informational purposes. It's not legal advice for your specific situation. Everyone's situation is unique. And so you should not be relying on this general information to give you a general idea of the immigration process and potential options for permanent residence. If you need specific assistance or have specific questions related to your own situation, then please feel free to consult one of our immigration attorneys or another qualified immigration attorney. So our agenda for today is really to, again, give you general information about employment-based immigration to the U.S. So when we talk about employment-based, we're talking about either through business or through employment or occupation that you are getting or trying to apply for what's called an immigrant visa. An immigrant visa is essentially permanent status. So they're the same as you can probably interchange immigrant visa with green card or permanent residence. It's pretty much the same. So we'll go over on our agenda today an overview of employment-based immigrant visa numbers. So to give you an idea of what the process is or how the government looks at how many applicants they're going to approve each year based on employment-based immigrant visa. We'll also then talk about the basic, the nuts and bolts of employment-based options for top professionals. So this will be no means, cannot be comprehensive in the time that we have, but we'll cover some of the key options, our main options that you could potentially consider for permanent residence. And then we'll talk about the green card process itself, the application process, and then finally a question and answer session as well. So this this picture depicts basically how complex the immigration system is in the United States. It is pretty much a maze. And so our job here is to try to give you some clarification and help you through help you see potential paths to permanent residence or green cards in the United States. So as I mentioned, we're going to talk about employment-based categories, what we call EB categories for immigrant visa, green card. So these are the typical processes for individuals to apply for permanent status. We won't cover all of these. We'll actually cover the first three. The last two are for another time, because what we're talking about here are top professionals, and we're going to talk about how you can actually petition for yourself for these types of green cards, whereas the last two are usually requiring an employer to sponsor you. So we're going to talk about outstanding researcher, extraordinary ability, and multinational executive manager category, which is the EB1 category. This is what they call the priority workers. And then we'll talk about EB2 category, national interest for all occupations as well. So moving on to give you an understanding of how the government how the government allocates green cards per each year based on employment. This is what we call our EB green card annual quota. The government has a fiscal year of October 1st to September 30th. So that is when they actually start with new numbers or new availability for green cards. So when I say numbers, there's about 140,000 green cards available each year based on employment. And as we'll see in the next couple of slides, there are other criteria to determine when a visa number, as we call it, or a green card number is available for an applicant. So as you can see, the first priority is given to EB1, what they call priority workers. So 40,000 is allocated to that. If those numbers are not used in any fiscal year, they may move those numbers down to the EB2 category, which already has 40,000, but can also receive other visas that are unused from the other categories. And finally, we have the EB3 and EB4 categories, which also have an allocation there. So this is just to give you an idea, or let you see that there is a quota each year for green cards. So it's not unlimited green cards based on employment applications. So how do they determine the allocation? So this is important to know when you're looking at whether you're applying for EB1, EB2, any of those EB categories. That says EB1 on the slide, but it's actually any EB category of green cards. There is a 7% country limit, which means that only 7% of no country can take more than 7% of the available visa numbers for employment-based green cards every year. In addition, so it's really critical to determine, or it's important to know where you stand in this situation, because it's also based on country of birth. So country of birth is really important to know, because of the 7% country limit. The country of birth is the criteria that's looked at to determine what country you are being considered for. And if you're from some countries that have a lot more applicants than others, then you could be subject to a what we call visa retrogression, meaning that there is a backlog of or there's a waiting list for that visa. But what's also important to know is that the applicant's country of birth, the primary applicant who is applying for one of these EB categories, the country of birth is important, but also the spouse's country of birth can be another or a deciding factor and can actually speed up a process. So for example, if your country of birth is India, but your spouse's country of birth is India, your country of birth is India, which has a long waiting list, but your spouse's country of birth is England, for example, or United Kingdom, then even though they are not the primary applicant, it's possible for you to speed up your green card process because they're by using your spouse's country of birth, assuming that you apply together at the same time. So that's a little much in the weeds, but I just wanted to be sure you understood that, because this is where it comes, this is where it's very important. So what I'm showing here on this slide is the visa bulletin, and this is the most current visa bulletin for March 20th, which is March 2023. So the visa bulletin is issued every month by the U.S. Department of State. And Department of State is the agency that covers all of the U.S. embassies throughout the world. They're actually the head of those U.S. embassies. So the Department of State keeps track of how many visa numbers are available based on family applications as well as employment applications. So there are 2 charts that are issued every month that's important for any applicant to consider. The first chart that I'm showing is the dates for filing chart. So this chart basically is going to be the same for the dates for final action. We'll talk about that in the next slide. But this chart is important to follow, particularly if you're from some countries which have a larger number of applicants each year. So as you can see, the chart is broken down into employment-based categories, EB1, EB2, EB3, and so forth. And then it's also broken down into countries of birth. So as you can see, the only countries of birth that are really defined here are China, El Salvador, India, Mexico, and Philippines, because they tend to have more applicants than others. So if you are not within this country, of any of these countries of birth, then you would be looking at this, what we call rest of the world column. So as you can see, the rest of the world tends to have a better or a faster, let's say, availability than some other countries or some other applicants or countries of application. So if you look here, you will see that this dates for filing is basically saying that this is the date. You would look at the cutoff dates. These are cutoff dates. These are the cutoff dates, for example, EB2, December 2022. So what this means is that if you did not apply before December 1st, 2022, you are not able to go to the second step of the green card process, which is the either adjustment of status or the immigrant visa process outside the United States, which we'll talk about a little more detail later. As you can see, for some countries, depending on the category, the cutoff dates are pretty far back. So for example, EB2 India, the cutoff date for filing an adjustment of status application is May 1st, 2012, which means that your application had to be submitted, your initial application had to be submitted before May 1st, 2012 for you now to be in the final steps of the process. So that's nearly a 10-year waiting period based on this chart in terms of filing. So you want to follow this chart. You can always follow this or find this chart at the website that I have listed here. Oh, and by the way, I do have the slides available. So if you look in the chat area, you should be able to find copies of these slides and download them as well. So this is important because getting into the final steps of the green card process is where most people want to be able to get your green card. So the timing of your green card really does depend on this visa bulletin. And I'll go to the next chart because this chart is also considered. It is the final action chart. So final action means the date, the availability of you getting a final approval. So even though you file an I-485 under the dates for filing chart, you may not be immediately eligible for approval of the green card unless you are also eligible under the final action chart. So this final action chart, for example, for employment base is current for EB1, which means there is no, C means current, which means there's no waiting time. You can, once you file your final step of the green card process, you can be approved immediately, assuming that all the processing has been completed. But if you had filed a let's say in the final action in the filing chart, dates for filing chart, you were able to file an application, but your final action date is actually later than November 1st, 2022, for example, in this EB2 category. So it can be a little confusing, but essentially, in order for you to get final approval, you have to have a priority date, which is the date of filing of your first step of the green card process before the cutoff date, which is shown in any of these charts. So if you're an EB1 and rest of the world category, you're pretty much in good shape. There's really not a waiting list. But if you're EB1 India, there is a cutoff date of February 22nd, February 1st, 2022, which means that only applicants who submitted their initial application before that date are actually able to be finally approved. So this is very important for many applicants. Some applicants, it may not be as important because there typically isn't a backlog or a waiting list, but it's important to know. So with that being said, let's go on to the actual categories of eligibility, depending on, well, it depends on, of course, your eligibility for these areas. So we're going to talk about the criteria for EB1A, EB1B, and EB1C. So this is the EB1 priority worker category that I mentioned earlier. And we'll talk about what's necessary in order for someone to qualify or at least apply for these categories. So if you look at EB1A, the advantage to EB1A is that there's no employer sponsorship. So this is one of the few processes green card processes that can be applied for without an employer. So you as an individual can actually apply for an EB1A if you can show that by your admittance to the United States, you can make a potential contribution through the work that you do currently. So, for example, if you are an engineer, a physician, a musician, any occupation, even an entrepreneur, if you have received or been considered to be at the top of your field on a national or international level, then you may potentially be eligible for EB1A and be able to show that you will have a prospective benefit to the United States because you are one of the top in your field on a national level. So what's important to know about this is it is a very subjectively evaluated application. So even if you have evidence of the criteria to prove that you meet the criteria, it is subjectively evaluated. So the government, in evaluating the application, may decide that the evidence is not sufficient, or even if you do submit evidence and they agree that you meet the criteria, they can very subjectively still not approve the application because they believe that it's still not sufficient to show international or national recognition. So just a little more detail about EB1. So the EB1A category has a total of 10 criteria that are considered. And out of those 10 criteria, typically the applicant has to show that they meet at least 3 of the 10. So these are the criteria that generally are considered for any occupation. So for example, if you have received national or international awards, that would be one criteria. If you can submit information about your receipt of the awards, as well as how the award is considered to be international or national, that is one criteria. Another criteria is memberships. So memberships relates to distinguished memberships, distinguished professional memberships. So for example, if you are a scientist and you've been admitted to a high-level membership within a organization that for scientists, and you also, or you're a member of a organization where only top scientists are admitted to this organization, then that membership could meet the criteria. The evidence is pretty strict, so you would have to show the actual criteria that the organization used to determine its memberships. You would have to show the publicity, for example, about that membership. If it's a membership that people, once they receive that membership, they send out announcements or they're interviewed about that membership, that sort of thing. Those are the kinds of things that they're looking for to show that this is a highly prized type of membership. Another category is publications. Now, these are publications, what they consider to be scholarly publications, meaning that your work, your publication or your articles that you write and are published either in trade journals, scientific journals, or professional journals, or mass media, newspapers, for example, that these articles are meant for people who are also in your profession. It's not a general article for the general public, but it's meant for others in your profession to learn and to learn from and to consider as part of their professional knowledge. So that is another criteria. Featured articles, it's just a general way, is another criteria where it's generally means that you've had media attention, you've been interviewed, you have been maybe interviewed for newspapers, journals, for television, radio. So basically you've gotten media attention about you and your work. This again is a criteria that does require a lot of detail, not only about the interviews, but about the actual media that was that featured you. So for example, if it's a television interview, we have to provide information about that television station and how well distributed or how well viewed it is. If it's radio, the same thing. If it's a newspaper, we also have to provide information about that newspaper circulation statistics to show that this is sort of a mass, or that the reach of these interviews or these articles is pretty far. And then the next criteria is judge or a judge of the work of others. So this is where you, as a professional, you have been asked to evaluate other professionals in some context, whether it's through reviewing their articles, scholarly articles, whether it's judging maybe even a contest, an entrepreneurial contest, if that's your field. Those are it varies, but whenever we're looking at these applications, we have to look specifically at your field and to determine what activities that you have done that would meet this criteria, and also provide evidence of that as well. As I mentioned, there are 10 criteria, so we're going to talk about the rest of the criteria for EB1. The next one is original contributions of major significance. So this EB1, as I mentioned before, EB1A is already very subjective, but this criteria is even more subjectively evaluated. So this is where the officer is looking at whether or not your work has made an industry change, or has improved your industry, or has been considered as a game changer in your industry. Again, it depends on each type of profession. For the more scientific ones, it's a little easier to do, but there are other areas as well that you can also consider. So again, when you're looking at your application and trying to meet this kind of criteria, we have to dig deep into figuring out how your work has been distributed or has been viewed as a game changer in the industry in some way. Another criteria is leading or critical role for top organizations. So this is a two-part criteria. First of all, you have to show that you have worked for an organization that is considered one of the top organizations in the country that you've worked in. So that's where we have to get information about the organization itself and prove that it is, highly ranked, highly viewed organization. And in addition to that, you have to show that your role in that organization has been leading. For example, if you're a CEO of the organization, of course, that's leading. Or if it's not that level of a position, then you also need to show that whatever role that is, it was critical to the organization because you did certain things that really helped the reputation of a department in that organization or division or the organization as a whole. Another criteria is high salary or compensation, and this is where you are showing that you have received a salary at any point, it can be currently or in the past, that is higher than the national average. Now, national average would be, and I do want to emphasize that when we're talking about EB1 national recognition, we're talking about whatever country that you are presenting. So for example, it doesn't have to be the United States. It can be any other country that you have had the most success in. So when we show that your salary is higher than the national average of the country that you're successful in. So that is the criteria there. So we have to get statistics, if it's available, surveys that show that this is the average salary for the position, but you have received a higher salary, preferably in the 90th percentile, like top 10 percentile. But that is typically what you have to do for this category. So some other categories, the other two categories that I'll mention is display at artistic exhibitions and commercial success. So those two categories are more related to the performing arts. So if you are in a performing arts field and you've had your work displayed, or you've had shows, you had different things to show that you are that you're well regarded in your artistic field, then these are the categories that you would look at: display at artistic exhibitions and commercial success. And then finally, we have sort of a catch-all category called comparable evidence, because some professions may not necessarily fit well into these different criteria, because it's just simply not something that's done. So for example, published articles may not be a typical thing for a coach, a high-level coach to do. So we also can sometimes present comparable evidence where we show that, for coaches who have had successful athletes that have won, top awards or top medals, that sort of thing, that is really the comparison that you have to make for coaches. And so we're going to provide that kind of evidence that may not fit into the other categories. So next, I'm going to talk briefly about outstanding researcher or professor. Now, this is an actual category that does require employer sponsorship. And it, as the title indicates, it's either someone who is a researcher or a professor, and that someone who is employed with a university, or if you're not employed with a university, you would need to be employed with a company that has at least 3 researchers employed with it, and that company has received, or those researchers have received, recognition in their field as well. So this is not a self-petition. This is for those people who are working with, as I mentioned, universities or companies, research companies. So this is the other requirement is that in order to apply, you must have at least 3 years of experience, and your 3 years of teaching or research experience, and your job offer has to be either permanent, tenure track, or a tenured job offer. And then finally, you have to show international recognition as outstanding in your specific academic area. So EB1B has different criteria than EB1A when we're looking at whether someone is outstanding. So there are 6 criteria that the government uses to determine whether or not they agree that the applicant is an outstanding researcher or professor. These are the 6 criteria. Awards, very similar to the awards category that I mentioned in EB1. So top level international awards, if you've received those type of awards, that would be one criteria. Memberships as well, if you are a member in high level membership, where there is significant accomplishment required in order for you to be a member. That is another category. And then articles about you. Again, this is similar to media attention. So if you have articles written about you or your work, that is the criteria. And then, of course, authorship of scholarly articles. So this is the research articles or articles, pretty much research articles being published, and judge of the work of others, where you are doing peer review, evaluating other people's work. And then finally, original contributions to the field. Original contributions to the field is a little different in this category than it is in the EB1A category, in that you need to show that the contributions are original, but they don't necessarily have to be deemed as major or game-changing. So EB1B only requires that 2 criteria be met out of the 6 criteria. However, there still is the same subjective review, final merits determination, where the officer, even if they agree that you meet 2 or more of the criteria, determines that it still does not meet to the level of international recognition. So it's very important to try to meet as many criteria as possible, and also to provide overwhelming evidence as possible to show that you do meet that criteria. So pretty much I'm going over again this two-part analysis that I just mentioned. For EB1A, the individual applicant must meet 3 of the 10 criteria. EB1B, the applicant must meet 2 of the 6 criteria. However, even if those criteria are met by the evidence that you submit, there is that third final merit or second final merits determination where the officer looks at, well, based on all this evidence, do I really believe that this person has international or national recognition? So going on to the next category, which is the EB1C category. So this is very different from the EB1 and EB1A and EB1 category in that it is really tied to employment with a international company. So this requires a multinational employer that has at least operations in the United States for 1 year and operations outside the United States for 1 year or more. So the foreign company and the U.S. companies must have a relationship to each other. So for example, if you have a company in England and it is owned, or you are working for a company in England and it's owned 100% by an individual shareholder, then the company in the U.S. must have that same relationship, either that the foreign company owns the U.S., so the U.S. is a subsidiary of the foreign company, or that 100% owner of the foreign company owns 100% of your company as well. There are some variations to that, but that's the simplest and easiest form of company structure that can show the qualifying relationship. So if the qualifying relationship is there, then if you are considered to be a top-level manager or executive, then you may qualify. So this shows, but you must show that the work that you did with the foreign company was a high-level manager or executive. So the application requires that you prove not only how your job in the U.S. is going to be high level, that it is going to be a top-level manager or executive, but you also have to show that your job and the foreign company also was same or similar to that in terms of being a high-level manager or executive position. In addition to that, as you as the applicant or the beneficiary employee must have worked with the foreign company at least for 1 year in the 3 years before either you apply for this EB1 category or before you entered the United States as under another type of visa, for example, an L1 visa or an E2 visa, or even an H1B visa. Oftentimes we get the question of, well, do I have to have an L1 visa in order to qualify for this type of application? And the answer is no. You could have had any type of visa. We've worked with people who have entered with an E2 visa or an H1B visa, but if they were able to show that before they entered the United States with those types of visas, they had worked with the foreign company on a top-level management position and are continuing to work in the U.S. company with a top-level management position, then they will also be able to qualify for the EB1C multinational manager category. So that kind of concludes the EB1 category that I mentioned. So we'll now go on to the EB2 national interest waiver category. So this is the other employment-based application that does not require an employer sponsorship. So this is another self-petitioning type of application, similar to the EB1A in that you actually apply individually for this type of application. But you must show that you intend to be employed in your own occupation, where you either have an advanced degree, meaning a master's degree or higher, as I'll talk about in a minute, or that you have exceptional ability in your field of expertise. And most importantly, that your immigration to the United States will benefit the United States on a national level, or be in the national interest of the United States to have someone with your skills, come to the United States and work on whether they're projects or work in a position that will somehow benefit the United States as a whole. So what are the specific criteria that we're looking at? So essentially as I mentioned before, you have to be either an advanced degree professional or exceptional ability. So here we'll talk about the advanced degree professional. So an advanced degree professional would be someone who has at least a master's degree or higher. If you have a foreign master's degree, you have to make sure that you get a equivalency evaluation to show that it is equal to a U.S. master's degree or higher. Or if you don't have an actual master's degree or higher, but you have at least a bachelor's degree or equivalent to a bachelor's degree in the U.S., and 5 years of progressive professional experience, then that can also equate to a master's degree. So for example, if you're an engineer and you have a bachelor's degree from France, and that degree is equivalent to a bachelor's degree in the United States, and you've also worked in your field for at least 5 years, then you can qualify for it as an advanced degree professional. If you don't have that, and if you're in a profession that typically doesn't, for example, need a degree, then you can potentially qualify for national interest waiver if you can meet the exceptional ability criteria. And this criteria, is listed here, there's 6 criteria, and you have to show that you meet at least 3 of them. So some of it kind of seems to overlap with the advanced degree professional, but essentially what they're saying is that if you have a degree, any degree, it may not be necessarily a bachelor's degree, it could be an associate's or some other degree that may not be considered equal to a 4-year degree in the United States. If you have a degree in your field of expertise, and you have a minimum of 10 years of experience in your field of expertise, and maybe you also have had significant recognition and about your contributions to the field. If you have those 3 criteria, potentially you can qualify for EB-2, national interest waiver, under the exceptional ability alien criteria. But again, as I mentioned, it's any 3 of these criteria. If you can submit those and be accepted for those, then you could qualify. So in addition to those qualifications, advanced degree or exceptional ability, you also have to show these 3 criteria, or meet these 3 criteria. First, your proposed work in the United States must be of national importance. So for example, if you are going to work on scientific projects that can benefit in healthcare, for example, or even in education, technology, or you're going to be working on projects that could have national import. You're working on a technology project that, if that technology comes through, it's going to be a breakthrough for the United States, or it's going to be a breakthrough for the industry in the United States. So it doesn't necessarily mean that it's the government of the United States that's going to benefit, but it could be that the general U.S. competitiveness or U.S. industries will benefit from this type of work that you're doing. You must also prove that you are, whatever the work that you're going to be doing, that you are well positioned to advance that work because of your past accomplishments. So this is where it's important to, even though it's not necessarily having to show exceptional ability because maybe you have a master's degree, but you still have to show that you've done certain things that have shown that you are better qualified than someone who maybe just has a degree or just has experience that is not as good as the experience that you've had. So that's where it becomes the 3rd criteria, where they're going to look at how will your work be beneficial enough so that we don't have to show that there's no other qualified people in the United States to handle this kind of position. So this is a little in the weeds again, but these are the things that you have to show as part of the national interest waiver. So those are the criteria that we're covering as far as are the 2 options, EB-1 or EB-2, national interest waiver for top international professionals. Again, this is not comprehensive because we don't have time to cover all of these, and I've already taken quite some bit of time to get to this point. But there may be other options as well, just depending on your background. So it's very important to meet with an immigration attorney to kind of see which which category, if any, would meet that you would be able to meet in order to qualify for these types of green cards. So let's say if you do actually, let's talk about how it works mechanically or procedurally in order for you to get to apply for these types of visas that I just mentioned. So step one would be, and it's a two-step process. Step one is to file an I-140 petition. And depending on which category, if you're EB1A and EB2 national interest waiver, you would be the applicant. But if for the other categories, you would have to have the employer be the applicant for the I-140 petition. If you are if you are applying under EB1B, EB1C, EB4, then the employer must also show that they have sufficient income or business income to pay the salary that they're offering you. And then in addition to that, you must show your qualifications. So that's where some of these applications can be very extensive because we have to show lots of documentation that you meet any of the criteria that you're trying to prove. So for example, for EB1A, you're going to have to submit at least criteria, at least documentation for at least five of the criteria. At least that's our procedure. You don't have to do that under the rules, but for our firm, we believe that at least 5 criteria should be submitted in order to have a good, strong application. And then finally, there's a premium processing option that is now open for any of these categories except EB4. So there's premium processing available for EB1 and EB2 national interest waiver categories. If you're applying for the EB1 categories, the EB1A and EB1B categories, the processing time is 15 days for the premium processing option. The other categories are 45 days processing time. So I'll just go on to the next step with the adjustment of status. So that's step 2. So there's 2 ways to, if your I-140 is approved and you're deemed qualified for EB1 or EB1 or EB2, there's 2 ways to actually obtain your permanent status and actually get the green card. You can either apply through adjustment of status or the immigrant visa process outside the United States. So adjustment of status is where you are legally in the United States and you have an approved or you have an I-140 application and you're able to file the adjustment of status because your priority date is current and you have valid non-immigrant status and you have not violated your status for more than 180 days. So for example, if you were on H-1B visa and maybe at some time there was an issue with your H-1B work where you maybe had unauthorized work. I'm not encouraging this, but if you had unauthorized work inadvertently, if that's not more than 180 days, then you can still apply for adjustment of status. The thing about adjustment of status is you can apply for I-485 separately for yourself and each family member that qualifies to immigrate with you. You will also receive during the adjustment of status process, you can apply for and receive an employment authorization called an EAD and a travel authorization document called advance parole. Typical processing time for the I-485 for you to actually receive the green card is about 12 to 36 months. And I know that's a wide range, but it really depends on whether your priority date is current, and because priority dates can go forward and backwards, and there can be a retrogression in the visa bulletin. And it also depends on where your application is processed. So unfortunately, there's not a premium processing option for adjustment of status. So you're pretty much at the mercy of the processing times at these immigration offices. The alternative to the I-485 process is the immigrant visa process. So this alternative may be the only alternative for some people, maybe the only option, particularly if you're outside the U.S. and you are not able to come to the U.S. in valid legal status. So you just don't have a visa to be in the United States. So in that case, if you have been approved for your I-140, then the next step would be the immigrant visa process, where you submit what's called a DS-260 form along with other information that the government requests. You have an interview at the U.S. Embassy wherever in your home country, And if the interview goes well, you receive what's called an immigrant visa stamp in your passport. Once you come to the United States within 180 days of receiving your immigrant visa stamp, you come in as a permanent resident. So processing time for an immigrant visa process can vary. It can be between 12 to 24 months or more. It just depends on, again, the priority date and the consulate that you're processing in. Like I said, this process may be the only process that's available for someone who is not eligible for is the only process available for someone who's not eligible for adjustment of status. So my final tip, information is tips for fastest processing. So when you're looking at filing for the green card, really pretty much through any process, employment-based process, what you want to do is determine whether or not adjustment of status is the best option for you, or the DS-260 immigrant visa option is best for you. And it's important to determine that before you file your I-140, because in your I-140 petition, you will be asked, what is your choice? Do you want to apply in the US, or do you want to apply at the embassy? And like I said, in some cases, the embassy is the only option. Sometimes it could be the faster option. So that's something to determine to begin with. Then you want to file, if possible, your I-140 and I-485 applications concurrently, meaning at the same time, if the priority date is current. Although we do suggest for EB-1A applicants that they obtain an approval first before filing an I-485, mainly because the EB-1A category is so subjectively evaluated that even if we have all the information required, it can still be denied. So you want to be assured that you have an approval before you take the next step of paying fees and applying for the I-485 application. If you want to, it's best to use premium processing for the I-140 petition. It tends to be a little more, it tends to speed up an adjustment application. It doesn't mean it's going to be within 15 days of approval, but if you have an approved I-140 petition, that is required for them to approve your adjustment of status application. So the sooner your I-140 petition is approved, the more likely your adjustment of status application can be processed faster. And then, of course, the last thing is to be sure to check your priority dates at the visa bulletin that I mentioned earlier to see if your visa, if you are eligible for immediate or eligible for final approval, or even applying for adjustment of status. So those are the tips for fastest processing. I know it's gone through quite a bit. So what I'd like to do now is to offer the opportunity for questions. As I mentioned earlier, please use the Q&A section, not the chat section, for your questions. So choose the icon with the little question mark there and add your questions in there. And I'm going to also bring in Attorney Celsa Rodriguez, so she can also answer questions at the same questions as well. So I think we'll just read off the questions. We have a question here regarding, excuse me, what happens, I'm sorry, these things kind of move around a little bit, but question number one, please, okay, I'm just trying to see which one this is. Okay. Please say word on recent January H1 settlement, H1B, H4 EAD premium processing. Specifically, how does one get an EAD without an I-140? So essentially, even if the H1 EAD was premium process, EAD will lag for behind 8 months after I-140 has arrived. These are a lot of questions. So I'm going to try to get through as many as possible. P&I is the fastest way of getting the 45 days. And if yes, then apply for all three. Okay, I think I understand the gist of the question here. So there was a recent settlement regarding the H1B, H4, and EAD premium processing, where it's my understanding that the government has now agreed that if you apply for premium process, if the H1B applicant applies for premium processing and also includes the H4 and H4 EAD applications, that they will process those applications as quickly as possible. I don't think they guarantee the time frame, but in the past, what we had seen was that they would premium process the H-1B, and the H-4 and H-4 EAD would come fairly soon afterwards. So they are somewhat agreeing that they're not going to let the EAD lag behind, or the H-4 lag behind, so far behind as it has recently, 8 months or more, waiting for those benefits. But if the question is, if you're going to apply for the green card through physician national interest waiver, for example, you want to get your I-140 as quickly as possible if that's going to be the basis for being able to apply for the H-4 EAD. So definitely, if you need the I-140 approval to be eligible for the H-4 EAD, then the primary applicant for the physician national interest waiver should apply for the premium processing so that they can get that as quickly as possible, and then apply for the H-1B, H-4, and H-4 EAD through premium processing. Follow up: what happens to those who are H-1B Conrad waiver physicians? Spouse already has H-4 but can't apply for EAD until we have physician national interest waiver or perm I-140. Can the employer reapply? Addendum. Okay, so the question still follows up on the H-4 EAD situation. So if you already have an H-4 and you're just applying for the H-4 EAD, then and you finally get your I-140 approval, or your spouse gets the I-140 approval, then yes, it might make sense to go ahead and do another H-1B, H-4, and EAD application. It's possible if the employer agrees to do so, and possibly get a faster decision on the H-4 EAD. We have a lot of H-4 EADs applications here, or questions here. So another question is, and Celsa, feel free to answer, can H-4 and H-4 EAD be filed with H-1B under premium processing if I-140 is valid and EAD is available for the first year at the time for H-1B? Well, if the question is there, I think the question is whether there's an H-4 EAD renewal under premium processing. Yes, I mean, certainly it can certainly be done that way. If you have a renewal, H-1B renewal, and I-140 is valid, and you still have an EAD that's valid, you can still apply for the EAD extension renewal at the same time. Another question is, do we provide free consultations? I will say that our consultations are not free. It requires significant time set aside from our client work in order to have a consultation, and we do provide valuable advice during that consultation. So our fees, we do charge a consultation fee of $175. So if you are interested, for 30 minutes, so if you're interested, feel free to contact us for our scheduling calendar. The next question is, what's the difference between EB-1A and O-1 visa type? So, well, the difference is basically that EB-1A is for green card. The O-1 is a temporary visa. So being a temporary visa, it does not lead to, or it is not permanent status. You will have to, for O-1A, you will have to keep renewing that if you want to remain in the United States. Now, the criteria for O-1A or O-1 and EB-1 are very similar. However, even if you have been approved for an O-1, it is not a guarantee of EB-1A approval. The officer reviewing the green card application makes their own determination and may not necessarily agree with the same thing that the O-1A applicant or O-1A application approval. So, but essentially the difference is it's a green card as opposed to an O-1. So there are some answers being typed in. I thought she was going to verbally answer, but there are some answers being typed in by Attorney Rodriguez. So please feel free to look at those as well. Another question is, can one apply for immigrant visa from another country where you have a resident permit that is not your home country? Yes, you can certainly apply for, if you are eligible through any of these processes or other processes for green card and you need to get an immigrant visa. If you have residence in a country that is not your birth country or your citizenship country, yes, you can qualify to process in that country. So just generally to qualify for an immigrant visa process in another country, um, you have to have residence in that country. So you either have to be a citizen or a resident of any country where you want to process your immigrant visa. And so Celsa is helping us out with written answers because she's not able to get onto the presentation. So please feel free to look at her answers as well in the question and answer pane. Another question is, could you speak a little more about how you can demonstrate you meet the NIW criteria for EB2? For example, as a researcher, is a certain number of presentations or publications, or citations that raise the chance of an EB2 NIW approval? Do all of these publications need to be in the same field? Are there any other strategies other than through publications and citations? So that's pretty, yes, there are different ways to present information, and it depends on the occupation. Really would have to look at each individual person and to see whether or not what they have to begin with, what their field of expertise is, what other evidence we can present to show that they are well qualified or well positioned, because that's what we're speaking to here, to show that you're well positioned or better, in some ways better qualified than others for this particular work that you're doing. Then we have to look at the type of occupation that it is. But if you are a researcher, as you mentioned, there is not any defined number of publications or defined citations, although we typically decide that, or typically recommend that you have at least 15 for an EB2. If you are a researcher, that you have at least 15 citations from your publications, and they can be in different fields, but we have to show how that work in past fields might relate to what you're doing now that's in the national interest. But for more details specifically on this type of criteria, I really do suggest that you contact us for a consultation so we can look specifically at your background and see if there's any qualifications that can be used to prove that you are well positioned for the endeavor. Another question is, if one has stayed for 4 months, can you still file an application for EB1 or 2, or is it better to go home and come back? There's a lot of timing there required, so it really does depend on your individual circumstances. It's potentially possible that if you are here legally on visitor visa, for example, and you've been here for 4 months, it's possible to file those applications, but it also depends on the priority date, which also depends on your country of birth. So there's many factors that we have to look at, but I would just answer that it is possible for that. Let me see. I'm just trying to make sure we have all these questions. We have quite a few, and I want to be sure that we are covering them. If there is an EB1 rejection, how soon can we apply? There's no requirement of waiting to reapply, but generally we like to wait at least 6 months just to see if there can be accumulation of other activities to add, professional activities to add and bolster the criteria. But it depends on what the rejection was about, or what the reasons were for the rejection. But there's no rule that says you can't apply as soon as your first application is rejected. You can reapply, but it may not make much sense to do so unless you have some newer information or can address some of the issues which might have been incorrect in the decision that you received, but you might be able to address some of those issues. Okay, and so I think the last question we have here, and hopefully I think we've answered nearly all of them. Is there any specific number of peer-to-peer review that we have to do for a EB1 physician? No, there's not any specifics. The thing about these applications is that they don't give you very much specifics, unfortunately. So normally we recommend at least 5 or more peer review, but the more you can do, the stronger your application will be. Okay, I think that concludes our time, and hopefully all your questions were answered. Again, I want to again emphasize that this is information, including the question, answering the questions, is only for informational purposes. It is not legal advice. So if you want legal advice about your specific situation, please do feel free to contact us for a consultation. Thank you again for attending, and we hope all of you have a great day. Thank you.